Company general meetings, and these are the types of meetings that will be held by a company from time to time in order to comply with statutory provisions, which require certain general meetings to be held in order to transact specified businesses. So we'll have statutory meetings. Those are as per the Act, they must be held. We'll also have an AGM, and we can also have an extraordinary general meeting, a class meeting, a directors meeting, and a creditors meeting. So a statutory meeting is under Section 130 of the Act. And this is for all public companies having a share capital, unless it's except unlimited. They are required to hold a statutory meeting. It's a compulsory. It's stated by the Act. It's compulsory. You're not given an option to not have this statutory meeting. And it is held after 1 month and not 3 months from the date at which the company is entitled to commence business. So remember, this is strictly for public companies which are except for the unlimited companies. And for this, the notice will be at least for 14 days. Remember that it's between a month and not more than 3 months before the commencement of the business, from the date rather at which the business is to commence. So 14 days is the notice, and a statutory report will be given. By virtue of that notice, you're given 14 days to go through the statutory report. And what are the contents? It will have a total of all the shares allotted, distinguishing shares allotted fully or paid up or otherwise. It has the total amount of cash received, and it has an abstract of the receipts of the company and payments made to a date within 7 days of this report. It has the names, the postal addresses, the description of the directors, the auditors, the managers, if any, and the secretary of the company. It also has the particulars of any contract that the company has entered into. And last, it has the certification of this company that brings it into its existence. So the statutory report, it must be certified. Once the meeting is held, this statutory report must be certified by not less than 2 directors. And at the commencement, the directors shall present a list showing basically a register of the members of the company and the number of shares held by each member. So what are the consequences when you're in default? Section 131, every director who knowingly or willingly refuses to do that is liable to a fine. And these statutory meetings, you remember that they are for public companies which are not unlimited. The register of members is made present, showing who has how many number of shares, what are their postal addresses, what amount remains unpaid on their shares, if so. We also have the annual general meetings, and this is Section 131 provides that every company shall in each year hold a general meeting as its annual AGM, in addition to any other meetings in that year, and shall specify the meeting as such in the notices calling it. So when you are sending out notices to the shareholders, you will identify that this is an annual general meeting. And in Gibson versus Barton, the year was defined as a calendar year. That is January to December 31st, not a financial year. the difference between a financial year and a calendar year. The calendar year is specific. It starts from January and in December. For the government, their financial year starts in July 1st, ends in June 30th. For any other company, depending on when you commence your business and you start that business, you can have your financial year starting from that certain month to another month. That is not the issue here. But for an annual general meeting, we use a calendar year. And Section 131(1) holds that so long as a company holds its first AGM within 18 months of its incorporation, it need not hold it in the following year. Therefore, if a company was incorporated on October 1st, 1992, it need not hold its first AGM until March 1994. We are counting the 18 years. If it holds its first AGM within 18 months, in that 1993, and for them, they will hold the AGM in 1994. So where there is a default again, the registrar may, on the application of any member, call for that AGM. And this is where the discretion is given. We talked about the exceptions. In these discretions, a sole member may constitute a quorum. And the registrar may not be bound to call or direct this meeting. But where a member feels aggrieved, they'll again go to court. So what is normally transacted at an AGM? You consider the annual accounts, the balance sheet, and the reports of board of directors and auditors. You basically examine how the company has been operating for those 12 months or for those months that the company has been in existence. This is where the dividend is also declared. This is not of the by directors. You remember we said the board of directors will propose. They already have the figures. They already have the idea behind whether to reinvest or to issue out dividends. So they will, after you consider the annual accounts, the balance sheet, and the reports, then the directors present that we have been able to pay off our debts. We are remaining with this surplus. And this surplus, we propose that a dividend be declared. For every share held, we are paying the dividend at 10%, give or take. We also have the appointment and the fixation of the remuneration of auditors. You remember, these are issues that will be discussed in the AGM. Then we have election of directors, where they are retiring. You're given a chance to elect others or to retain them. This is normally done at the AGM, annual general meeting. We also have an extraordinary general meeting, and this is section 132 of the Act, and it's called as any other meeting of shareholders. It's called an extraordinary general meeting, and again, it's a 14 days in writing, notice in writing, but where we are passing a special resolution, then you're given 21 days. And for this EGM, shareholders are given certain rights. And the members can requisition as long as there's members holding not less than 1/10 to have this meeting. And for any reasonable expenses by the requisitioning members, by failure of the directors to convene, then they can be recovered from the company. The extraordinary general meeting is requisitioned by the shareholders, and it's for passing the special resolutions. So we also have class meetings, whereby we can have, you remember the shares have different classes. So you can have the different, if it's preference or redeemable, they have their own special meeting. It's not a general meeting, but similar rules during the convening and conducting. And the articles may provide that a certain matter affecting the interest of the holders of a particular class of shares be subject to the consideration and decisions of a meeting of those holders only. For example, Table A states that if any time the share capital is divided into into different classes of shares, the rights attached to any class, unless otherwise provided, may, whether the company is being wound up or not, be varied with the consent in writing of the holders of 3/4 of the issued shares of that class, or with the sanction of a special resolution, pass whatever the issues they need to do that. So the articles will provide for these classes, the different classes of shares. And again, the articles provide for what will be discussed there. So Section 207, in regards to class meetings, holds that if the company makes a default in complying with the regulations, anyone who's in default is liable to a fine. So we also have directors' meetings, and this is the board meeting. And this is where the directors come together again for the benefit of the company. We have a creditors' meeting, and they're only relevant during the winding up of a company. As we talked about debentures, they can call for a meeting to identify how best to recover the money owed to the company, the money lent to the company. So how do we convene a general meeting? And Article 49, Table A in the Act. So a director or any two members can convene an extraordinary general meeting. The Section 122 again empowers members holding not less than 1/10 of the paid up capital to convene that extraordinary general meeting, where if the directors have failed to do that. So you remember, as we started, we talked about the essence of collecting this law. This is why we are quoting the articles. The Companies Act has a sample article, what can be followed, what will guide the companies. And we quote sections. Meetings are a way of the company doing their business. So how they are convened is set out in the Companies Act. Table A, Article 49 provides it relates to a quorum. It relates to where directors fail to do their duty and members take up that duty.